We're very pleased tonight to have Peter Kirsch with us, and his topic, I think, is going to be one of great interest. Peter is a partner for more than 35 years with the Kaplan Kirsch Law Firm, and the Kaplan Kirsch Law Firm has a worldwide reputation in aviation law. The Kaplan Kirsch lawyers have advised clients for decades on the complex legal issues relating to airport noise. They have counseled more than 60 airports, large and small, on strategies to reduce airport noise and to mitigate its effects. They have litigated and won complex cases on behalf of airport sponsors, challenging next-gen flight patterns in flight tracks, defending noise abatement measures, and defending environmental law reviews. I might also note that for those of you who have had the opportunity to attend the UC Davis Aviation Symposium that's held on an annual basis, Peter has been a frequent speaker, and when he's been a speaker, he's been the most popular speaker on the agenda. He brings a wealth of information, and we are delighted that we're able to get him out of Denver today to come and join us to give us a presentation. We've asked him to speak for about 45 minutes and then to take questions and answers for about the same. So we're trying to leave adequate time because I know a lot of you have had questions on what tools do we have as residents and as members of this board. And I think Peter can shed a lot of light on that and where we are today and how we got to where we are with respect to our metrics. So Mr. Kirsch, the floor is yours. Welcome. We're delighted to have you.
Thank you, Mr. Chair and members of the committee. You can hear me okay, can't you? Good. I'm going to stand just because it's us short people have a hard time sitting and being noticed. And there are an awful lot of slides here, and I'm going to run through them pretty quickly, but I assumed that all of you would get copies of this so you can look at the pretty pictures later if you so choose. But here's what I'd like to do. I want to do a little bit of a history lesson here about how we got where we are today with the measurement of noise and talk a little bit about what the prospects are in the future with a slight detour as to what is going on right now in Washington or what was going on in Washington with respect to FAA reauthorization. If we can go to the next slide, please. So we'll start with how we got to where we are today, a brief history of noise measurement and reporting, and what I'll call an inflection point today with respect to reporting and measurement of noise and a modest proposal for what we might look at going forward. Next slide, please. This is actually the text of what I was going to say. Next slide, please. Let's go into the Wayback Machine of Internet Archive and look back, if you will, 50 years. Next slide, please. To the 1970s. Next slide, please. Things were quite different in all kinds of respects in America in the 1970s. Next slide, please. Including most especially the aircraft. And I look around the room here and I see most of you probably don't know a lot of these aircraft. Maybe you weren't even born when these aircraft were still flying. But it's important to recognize, how many of you remember the Whisper jet? Okay, we got a couple. The Whisper jet was not whispery, let me assure you. And today the Whisper jet would be by far and away the noisiest plane in America were it to exist. But it was the Whisper jet in the 1970s. That's really important to understand. Okay, it's really important to understand the nature of aircraft noise in the 1970s and the advent of the jet age and what it did to increase the environmental awareness of noise. Remember, the 1970s was a period during which, in general, in America, we focused a great deal on environmental sensitivity. That was the era of Silent Spring and Love Canal and so on. And noise was no exception to that. We began to realize that the noise that we were living under at airports was really quite extraordinary. And as a result, local airport sponsors came under increased pressure from the communities around the airports to adopt a range of measures from voluntary measures to draconian curfews. If we can go to the next slide. Coming out of the 1970s, a metric was developed for measuring noise. I'm going to go back and explain how we got to this metric, but it's really important to understand, as I'm sure all of you do much more than the public, that the DNL metric is an averaging metric, and so it measures what the average noise is in an area around an airport. And going back, if you will, to the Whisper jet, one Whisper jet can make as much noise as 100 of a much quieter kind of jet. And the reason that's very important to understand today is that we are seeing a considerable increase in traffic at airports around the country, not just at SFO, at a lower level. And so how that reflects on the DNL is important. So if we can go to the next slide, please. So how was DNL and the 65 decibel, by the way, CNEL in California is practically speaking similar to DNL. But how was DNL and 65 selected? The Noise Control Act of 1972 directed the EPA to select a cumulative noise metric and to publish levels of noise that are requisite to protect public health and welfare with an adequate margin of safety. This was EPA's directive in 1972. A number of technical studies resulted from the 1972 Noise Control Act, including a document which we now refer to generally as the levels document. And I don't even remember the full name of it, but it's long and technical, in 1974. And that was followed in 1976 by the FAA noise policy. What's really important to understand is this noise policy was designed to balance between desirable and technical and financial achievable levels of noise. And keep that in mind, because neither the FAA noise policy in 1976 nor the Noise Control Act of 1972 was designed to be an absolute measure of noise. It was designed to set a metric and set a threshold that was a balance between the various needs. And keep this in mind, because that balance in 1972 may in fact have been different than it is today. If we can go to the next slide, please. So a number of other federal laws have passed since 1972 addressing noise, and we can go into deep detail in any of these if you want, but I just want to take a quick run through them, including the Aviation Safety and Noise Abatement Act of 1979. This was the statute that directed the FAA to establish a single system for measuring noise around airports and to identify land uses that are normally compatible with various noise measures. Of course, all of those, as you know, are recorded in the Part 150 regulation. So the statute, the ASNA, A-S-N-A of 1979, was the statute that really created the Part 150 program that was adopted as regulations in 1980. So let's remember, we're now 8 years out from the Noise Control Act, and the FAA has said, here is how we are going to do noise planning around airports. There have been subsequent statutes as well, including the Airport Noise and Capacity Act in 1990, and the FAA's proposed noise policy, which is going to be finalized soon because it was issued in draft in 2000. That was a joke, by the way, in case you weren't. But it's really important to understand that history, because you need to understand what the FAA was doing in 1970, what Congress told the FAA to do in 72, what FAA did in 1976, and what Congress did in 1979 and the FAA in 1980 for establishing various metrics and thresholds for measurement of noise. If we can go to the next slide. And as a result, it's really important that we make some distinctions here and that we be precise when we're talking about noise measurement. There's regulation of airport noise, regulation of aircraft noise to be more precise. And those regulations are set forth in the Part 36 regulations of the FAA and are set in many cases by treaty and by international agreement. That is the noise generated by aircraft. The second is reporting of noise, and that is ASNA and Part 150. That statute and that regulation are designed to say, here is how we are going to report noise based upon the balancing that I just talked about practicality and technical issues. Third is planning for future noise, which is also a component of the Part 150 regulations and the Part 150 process. That is designed to say, let's look at what the noise will be in the future, and let's plan to make sure that we minimize the amount of incompatibility between an airport and its neighbors. Then we also have mitigation of noise, that is dealing with the fact that there is incompatibility between an airport and its neighbors, and that also is set forth in Part 150 and in regulations for federal funding of AIP grants and passenger facility charges. And finally, we have abatement of noise, that is measures to stop the effect of noise. And that is addressed in a number of environmental statutes that often have nothing at all to do with airports. The reason I want to make these distinctions here is that as we start talking about the measurement of noise, we need to understand why we are measuring noise, why we are setting a threshold. Are we doing this for regulatory purposes, for reporting, for planning, for mitigation, or for abatement? And each of those is different. And I would argue, and I'm going to say a little more in a couple moments, that there's no reason why the metric and the threshold needs to be the same in each of those instances. Next slide, please. What has happened as a result of ASNA and Part 150 in 1979 and 80 is that the methodology that was adopted as a result of that statute and those regulations has really been bootstrapped into all those other forms of noise that I mentioned in the previous slide. That is, ASNA was designed to be a statute, and 150 was a regulation designed to to report and plan for future noise. The FAA then said, we're going to use that same methodology for reporting environmental impacts under the National Environmental Policy Act and ultimately under the California Environmental Quality Act. And we are going to say we're going to use the same methodology, we're going to use the same metric, we're going to use the same threshold for that. But the purpose of that statute is really quite different. That statute is not designed necessarily to balance between technical needs and the cost of mitigating noise, the cost of abating noise. It's designed to report environmental impacts. But the FAA, through their orders and various directives and advisory circulars, says this is the metric we are going to use, and the courts have deferred to the agency's view that they're going to use the same metric that they adopted over here for another set of statutes over here. And that's NEPA, the Environmental Impact Statement Process, Section 4F, and Section 106, which are specialized statutes designed to protect the integrity of parks and historic properties and tribal resources. Again, the FAA used the same metric that had been adopted in 1979 and 80 for purposes of planning, for the purposes also of environmental reporting. The FAA then later in 1990 adopted again the same metric and the same methodology for what's known as the Part 161 analysis, or the analysis that's necessary if an airport wants to restrict operations for the purpose of reducing noise. So what we see here is a metric and a threshold that was established for one purpose that has now sort of creeped into all these other purposes and has become almost ubiquitous in the measurement and the reporting of noise nationwide. Now, a number of court decisions, literally dozens and dozens of court decisions over the course of the last 50 years, have said a couple of things. And keep this in mind because I'm going to come back to this point in a moment, which is the FAA was given the direction by Congress to adopt a single metric and a single threshold. And therefore, that's okay. That is, the court said it's okay to use one metric and one threshold because Congress told them to. And we, the courts, really don't understand noise, so we're going to defer to the agency that not only has expertise, but has been told by Congress to develop the expertise to report on airport noise. And frankly, nobody could give the courts any meaningful alternative to the DNL metric and the 65 threshold, and the FAA therefore generally wins these cases. So if you can go to the next slide. So the evolution of the legal importance of the 65 decibel DNL threshold was developed for a very narrow purpose in the 1970s and 1980s. It was the first time that the federal government said we are going to report airport noise uniformly across the nation. And its acceptance, the acceptance of that metric and that threshold have evolved, gradually becoming so widespread in reporting, planning, mitigation, abatement, funding, all the things I talked about a couple moments ago, that it essentially is the way in which airport noise is reported and the way in which airport noise is mitigated. And the use of the 65 decibel threshold today is really enshrined in law, as a result of court decisions, in regulations, in policies, in guidance, and in past practice, that is legal precedents. And so the importance of 65 and the DNL metric has really sort of gradually seeped into the entire culture of how we look at airport noise. So if we can go to the next slide. So let's talk a little bit about DNL and 65 and, if you will, sort of the reality. And to this crowd that's sophisticated and understands this, I don't think any of this is going to come as any particular surprise to you, which is it is not, by the way, the only metric that can be used to report noise. Big surprise, right? Many people don't know that. They think this is how we do it. And it may indeed, in 1979, have been the best metric given the mandate that the FAA was given under ASNA. That is, remember, the mandate to develop a single metric nationwide, to develop a single threshold nationwide that balanced economic and environmental concerns. It may indeed have been, and by the way, today it may still be the best metric using that standard, using that principle. So it has developed now as the one methodology for assessing noise levels. Yes, there are other ways we can do it, but by and large, most reporting of airport noise nationwide is done with reference to the DNL and the 65. What's really interesting is that the basis for selecting 65 as the threshold and DNL as the metric was based upon dozens of studies, technical, good quality scientific studies that were done from the 1960s to the 1980s. And that's important. Remember I showed you the Whisper Jet? Okay? These were studies that were done when the Whisper Jet was the latest, newest, quietest technology. And these studies examined what noise levels would be acceptable to people, what noise levels people would find to be disturbing. Now, it should be no surprise that as society has developed over the course of the last 50 years, what's acceptable to us has changed. You know, when my parents grew up in New York City, the level of air pollution that they accepted today would be appalling. I mean, how many of you have been to Los Angeles, right? You know, the level of air pollution that Los Angeles accepted in the 1970s and 80s today would be plainly unacceptable. The level of water pollution we accepted in the 70s and 80s would be unacceptable. But interestingly, the level of noise that we measure is exactly the same as it was in the 1970s and 80s. In other words, we are using the same methodology, we are using the same metric, the same threshold that we used back then, whereas other sources of environmental impacts have evolved over the course of the last 50 years. Now, this isn't a criticism necessarily, it's simply a statement of fact that we continue to measure noise the same way. And the choice of metric that was selected in the 1970s and 80s was designed to achieve a policy balance that made an enormous amount of sense in 1970 and 80. I mean, this was a time when airports like New York or even San Francisco had literally hundreds of thousands of people living within the 65 DNL contour. I mean, the numbers for today would just be staggering. I mean, there were millions and millions of people nationwide who lived within that noise contour. It's a fraction of that today. But again, because of the balance that Congress directed the FAA to achieve, it made an awful lot of sense. It's important that when we start analyzing DNL and 65, that we avoid conflating the metric and the threshold, because those are really very different things. DNL, being an averaging metric, makes a lot of sense in many respects, but it makes no value judgment. DNL is a calculation, and Gene will be happy to tell you how it's calculated, because I don't know. But it's a technical calculation that has some consistency over time. 65 is not that. 65 is a value judgment. 65 is a judgment that was made by the FAA in the 1970s and 80s that said, this is a level of noise beyond which the communities will find noise to be offensive. And why did they do that? Because there were a number of studies from 1960s through 1980s that said that. And it's important to recognize that neither 65 nor DNL is the metric that's used for regulation of aircraft noise internationally. That is, the Part 36 regulations by the FAA and the international regulations are not based upon either DNL or 65. So it's not the only thing we could use, but it is the one that we've been using. If we can go to the next slide. This is kind of hard to see on the slide. I hope folks have a copy of this. But I think what it shows, if you just want to look at the shape of these lines, is the population in blue that's exposed to noise over 65 from 1975 to 2012 decreased dramatically. And the number of enplanements, that is the number of people flying on aircraft, increased, not quite so dramatically, but increased very significantly. And the reason is, of course, because of improvements in technology. So if we can go to the next slide, please. So let's stop for a second and look in the year 2000, 24 years ago. Let's do a quick report card on how 65, how DNL was working. And this is my view. It's not the view of anybody else in particular. And you can throw tomatoes at me if you wish, because it's sort of just based on my own experience. But I would say, in the year 2000, the DNL metric, I'd give him an A-. I'm a pretty easy grader, by the way. So I'd give the DNL metric an A-. I'd give the threshold probably a B. Remember, we're talking at 2000, okay, 24 years ago. Local land use planning based upon DNL and 65, I'm giving a C- because I don't like giving Ds. It was really quite poor. That is, the effectiveness of land use planning as a measure, as a way of achieving compatibility between an airport and its community was not doing very well. The value of 65 in DNL for reducing conflict, yeah, B-. Maybe that's a little generous. Maybe I should say a C+ there. The use of 65 as a basis for avigation easements, that is for requiring homeowners and other property owners to sell a right to overfly their property, which was designed to give compensation to homeowners for noise impacts, C-. Barely any value at all, okay? For Part 150, not bad. Not bad. It was working quite well as a planning tool, as a tool for looking out 20 years, for being able to compare San Francisco and San Luis Obispo, or comparing San Francisco to Sun Valley, Idaho. It wasn't bad, because from a perspective of a national agency like the FAA, it did well. And in terms of community, airport, and FAA cooperation, again, not particularly well. It was not working very well by 2000. Remember, this is a metric now that had been in effect for 20-something years. So, next slide, please. If we could fast forward to the 2020s, next slide, please, and another inflection point. I think it's important to recognize that there have been a number of studies, all of which have the same name. FICUN, FICON, FICAN. I don't know, what is this about federal agencies? They have to come up with these, anyway. So there have been a number of studies done on the issue of how does noise affect people. And these studies have been validated over a course of years. And it wasn't until 2020, or more accurately 2021, that the FAA said, let's do a new survey to see whether or not the data upon which 65 was established remains valid today. And the FAA did that under direction from Congress and under intense pressure from communities and airports to say, is it conceivable, I know it's outrageous, but is it conceivable that people's expectation of noise has changed since 1970? Remember, I talked about air pollution and water pollution and so on, but probably not. But let's do it just in case, okay, in 2021. Next slide, please. That resulted in the Neighborhood Environmental Survey that was conducted at the direction of Congress and was released to the public in 2021. Keep in mind, by the way, it was released to the public in 21. The study was actually done a couple of years earlier. The FAA sought feedback on the results of this study. They got some 4,000 comments from the public about the study, which resulted in a notice that it's going to prepare a new noise policy. Remember, I said in year 2000, the FAA drafted a noise policy that hasn't yet been adopted. So 23 years later, the FAA announced that it's going to review the noise policy. So let's look and see what we learned, thank you, from the 2021 Neighborhood Environmental Survey. This is a curve that shows what what data was used for selection of the 65 decibel threshold in ASNA, in Part 150, and then ever more since 1980s. What this curve is designed to show is the percent of people who are highly annoyed at different noise levels. Known as the Schultz curve, it's been established sort of as the, in many respects, the cardinal way in which noise is examined. And you can do your own assessment here, but at 65 decibels, the Schultz curve showed about 15% of the population is highly annoyed. Let's go to the next slide. Here is the curve. Can you go back to the other slide quickly? Okay, let's do it again. These are really different curves. This is the curve from the FAA's Neighborhood Environmental Survey in 2021. It doesn't even have the same shape. It's way higher, so that if you go to the national curve again at the 65 decibel, instead of 15% of the population being highly annoyed, we're talking about 60%. That shouldn't surprise anybody. That people's level of annoyance, people's expectations of quiet have evolved over the course of the last 40 to 50 years. Not a surprise. What are we going to do about that? I mean, that's pretty radical. That's a pretty different looking shape. So if we could go to the next slide. So one could argue that the Neighborhood Environmental Survey could be the basis for new conversations about these issues that were established in 1979 and 80, that is the metric and the threshold and the significance of impacts. Is it okay if instead of protecting the 15% of the population that's highly annoyed at 65, we're now going to protect the 65% who are highly annoyed? Is that what we want to do? Is that the same balance we want to achieve? And the result of that was the FAA said, okay, we'll look at this. We really will look at this. We are going to review our noise policy to see whether this data point, the data point from this study, justifies a change. And one of the really interesting phenomena that came out of the Neighborhood Environmental Survey was intense pressure on the regulators, on the FAA, on legislators, that is Congress, and on airport sponsors to adapt to the findings. Now remember, this is just a scientific study. It doesn't have the force of law. It hasn't been memorialized in regulations or policies or anything like that. It's a data point, and it's a really interesting data point. So if we can go to the next slide, thank you. But the data point by itself is not enough, because it's important to distinguish the metric that is set forth by statute and the threshold, the 65, that's set forth by regulations. And it's important to recognize the difference between law and policy. You know, we can sit here and debate policy all the time, and we do a lot of that, but we have to recognize that the FAA has to operate under the law. So the question is, if we think that the Neighborhood Environmental Survey is an accurate depiction of how people feel in 2021, are legislative changes necessary or even desirable? Should we be saying, hold it, 65 worked in 79 and 80, maybe the number is different, or maybe the metric is different. Should we be looking at all of those? The problem is that the process that we had that developed the 65 and the DNL in the 79 and 80 would have to be replicated. That is, we'd have to have a transparent process. We'd have to go through a thoughtful review. It certainly would have to be collaborative, and the amount of collaboration, the amount of transparency the public expects today is considerably greater than it was in the late 70s. If the FAA, if the federal government is to change its threshold or its metric. And then the question, of course, becomes, okay, suppose the FAA says, we think the Neighborhood Environmental Study is wonderful. We are going to change all of our policies, those that we, the FAA, can change based on that, and we're going to ask Congress, please give us new direction. But then what happens to state law? And what happens to CEQA? What happens to all the court decisions that were based upon the law that existed then? And what about, my last line, Chevron and other principles of deference? And this is a throwaway line that I've used for the last many years. And how many of you know what I mean when I say Chevron deference? Okay, I could have asked this a year ago, and nobody would have any idea. I'm going to give you a little bit of law 101 in a moment. But if we can go to the next slide here, because I think Chevron deference is very important in this context. So there are some options going forward. I mean, the agency, the FAA, could make revisions in either the metric or the threshold itself through FAA regulations, NEPA, Part 150, Part 161, what airport revenue can be used for PFC funding, for AIP funding, and so on. Because the FAA does have some policy flexibility in some instances without abandoning what Congress told it to do, which is establish a single threshold. But there are other federal agencies that are affected by this as well, like EPA and HUD and VA and other DOT modal agencies. So you have to be careful about thinking based on this one this one data point in the neighborhood environmental study, what the ripple effect would be through the government. We can go to the next slide. One thing that did come out of the neighborhood environmental study that I think is both very important and very depressing is that there's a growing consensus that there isn't a consensus. That is, there's a growing view that we don't know what to do next. The 1979 and 1980 analysis was based upon years of data. We now have a new data point that suggests maybe those years of data were not exactly useful for 2024. But nobody has decided for sure how to deal with it. As Airports Council International North America said, it's critical for the FAA to take into account and reflect the different experiences in different communities. Well, that's an interesting idea, because Congress said adopt a single metric and a single threshold for nationwide measurement of noise. Wonder what ACI means when they say different experiences in different communities. Could it be, well, this is ridiculous, but could it be that the level of noise acceptable in Queens, New York, and the level of noise acceptable in Lake Tahoe are different? I don't think so. I doubt it. But after all, Congress said establish a single threshold, right? And so what ACI is saying, you know, it may be that Lake Tahoe and Queens are different places, and maybe these are communities with different expectations. But Congress has said, in 1979, establish a single metric. Then you have members of Congress, including your own members from the Bay Area, who say, well, my community is special. You know, my community is particularly concerned about noise, and so you may want to have a national standard, but in my area, we are more concerned about noise than anyone else. The result of that is nothing happens. Because if you have 532 members of Congress and Senate, and each of them thinks they're special, it's going to be really difficult. It's going to be real. I mean, and they are all special. I can assure you they're all special. And so it's very difficult to say, well, should we in fact abandon the idea of a nationwide standard? And the nationwide standard has been really very, very effective in funding, very effective in being able to report across airports what noise impacts are. But should we abandon that? There has been, not just because of the neighborhood environmental survey, but other developments, technical developments in acoustics, a gradual acceptance of alternative supplemental metrics for measuring noise. But these don't have any legal significance, and Gene can talk to you at great length about other metrics that have been used, particularly in the context of overflights and Metroplex and so on, other metrics that can be used to report, but they don't have legal significance because Congress told the FAA to adopt a single metric and a single threshold. And so what's really interesting, I think, today is it's a bit of deja vu back to the 1970s and 80s when Congress said, this environmental protection stuff is getting out of control. Let's adopt a single metric and a single threshold for the nation because there was so much concern, and we're seeing the same thing coming up today. So if I could go quickly to the noise policy review that the FAA is doing right now, because I think this is really important to understand that as a result of the neighborhood environmental survey, the FAA said we are going to review our noise policy. We expect the FAA will issue something about the noise policy tomorrow or the next day, maybe early next week. And we think what they're going to say is we're not going to issue a new noise policy yet. We are going to appoint a committee that's going to look at how we should look at whether we should look at what we're going to look at when we look at the noise policy. Did I get that right? Did I get that right, Gene? Okay. I think I missed one look at in there. And I'm being only slightly sarcastic here in that the FAA has a really, really difficult job. because they have to now figure out, essentially go back to what they did in 1979 and 80 and say, what should we do? Well, enter, next slide, Chevron. So anybody want like a little law school 101 here? Okay, good. No, it's not Chevron. Actually, it is Chevron Oil. That's wrong. It is Chevron. But let me tell you what Chevron is. Next slide, please. Chevron is a legal doctrine that says that the courts defer to an agency's permissible interpretation of a statute that it administers where Congress has not explicitly addressed the question at issue. Now, let me try to rephrase that in English. What that means is if Congress has told an agency to do something and it does a pretty damn good job of it, it's permissible. That is, they have interpreted what Congress told them to do pretty well. The courts will say, you're the expert. We are not going to try to learn everything there is about acoustics. The FAA is the expert in airport noise. And so when Congress said, FAA, we would like you to adopt a single metric and a single threshold, if their interpretation of that statute is permissible, the courts will say, we're going to defer to you. And that's what's known as Chevron deference. And there are two steps to Chevron deference. Has Congress spoken directly to the issue, and is the agency's interpretation based upon a permissible construction of the statute? Now, why is that so important? It was articulated by the courts beginning in the 80s because federal agencies have subject matter expertise, including the FAA, for example. And federal agencies are overseen by the president and thus, in a sense, accountable to the people in a different way than courts are. And deference fosters stability and uniformity in the law. So you don't have every judge saying, I am really smart when it comes to acoustics. I'm going to go back and reread all the studies and make my own judgment as to whether or not DNL is a good metric or not. Can you imagine what would happen if every judge did that? It would be, it would be really kind of ridiculous. And the fact is that federal agencies spend a great deal of time and can act more efficiently and effectively if they are given a degree of deference. So that has been the law at least since the 1980s, probably somewhat before that. So next slide. So enter the fishermen. A couple months ago now, the Supreme Court decided two cases called Loper-Bright Enterprises versus Raimondo and Relentless versus Department of Commerce. The Loper-Bright case was a challenge to the National Marine Fisheries Service rule that required industry-funded monitors to be on board fishing vessels. The details don't really matter for this purpose. So what did the Supreme Court say? Next slide, please. The Supreme Court said, whoops, Chevron was wrong. And by the way, it is quite unusual for the Supreme Court to overrule a precedent. It happens. It's happened many dozens of times over the course of American history, but it's quite unusual. And the court said, whoops, Chevron was wrong. The courts shall exercise independent judgment in determining the meaning of statutory provisions. And there were three dissents, but the Supreme Court said it is not appropriate for us as the courts to defer to the agency's interpretation of a statute. We get to do that. That's our job as judges. Next slide. So what does this mean? This means that when someone goes to court to challenge, say, the FAA's interpretation of ASNA, the FAA's interpretation of NEPA, the FAA's interpretation of any number of statutes they've interpreted, no longer do the courts say, you are really smart, FAA, we're going to defer to your judgment as to what the statute told you to do. The court will independently exercise judgment. What's this likely to mean? Good news. This is a Lawyers' Full Employment Act. No, that wasn't funny. That was actually serious. It is really good for me. There are increased opportunities for litigation because more litigants are going to say, well, here are the 16 cases where the courts have deferred to the FAA on the issue of noise, but mine's going to be the case where they're going to stop deferring because Chevron doesn't exist anymore. There's a great deal of potential for regulatory uncertainty and non-uniform application of regulations, and that's particularly true in the noise realm. Remember how I told you how the one principle of one metric and one threshold that was adopted in ASNA has now been spread through the entire federal system? Well, now there's going to be an opportunity for somebody to come to court and say, wait a minute, just a second. ASNA is ASNA, and NEPA is NEPA, and ANCA is ANCA, and all the other statutes are different statutes, and the FAA's interpretation of the statute is not entitled to deference. So, next slide, please. So what hasn't changed as a result of the Supreme Court's decision a couple weeks ago? Congress can still delegate policy-making authority to the agencies. That is, the Congress could say to the agencies, we delegate to you the decision as to how you're going to do X, Y, and Z, okay? The Chevron case, or the overruling of Chevron doesn't apply retroactively. That means that if somebody previously sued and lost, they can't go back to court again and say, courts, will you re-examine this? And here's what's really important to keep in mind in this context. The Supreme Court overruled the Chevron principle that the courts will defer to agencies' interpretation of statutes, but agencies will still receive deference with respect to fact matters and matters where their opinions are persuasive and well considered. Okay, so it didn't mean the courts are going to redecide everything, but it means that if the agency is very careful, and if the agency does a good job of interpreting and applies facts, the courts will still defer to them. So it doesn't get rid of it entirely, but it means that there's going to be a much more nuanced examination each time somebody goes to court. So if we can go to the next slide, the corollary principles, things that were not affected by the Supreme Court decision, are two other principles in law. You didn't know you were getting all this law here today, did you? That's good, that's good. Things called Skidmore and Auer deference. These are much, much, much more important for us. And let me tell you why. Skidmore respect, sometimes called Skidmore deference, says that when an agency interprets what its role is, not just in regulation, but in policy, the courts will defer to that based on the soundness of the agency's reasoning and expertise. And Auer says that courts will defer to an agency's interpretation of its own regulations. Well, when you look at noise issues, very, very little is in statute. Almost all of it comes from policy and from regulations. And so what that means is that although Chevron doesn't exist with respect to the agency's interpretation of statutes that it's charged with, the other principles in terms of the agency's interpretation of its own regulations, Part 150, the NEPA regulations, still exist. And so with respect to noise issues, it's going to be much more difficult to argue that the Supreme Court now says that we have to throw out all the past precedent on noise because most of the noise decisions are interpretations of the agency's own regulations. So next slide, please. But we need to recognize a judicial trend that the Supreme Court's decision overruling Chevron deference does not stand all by itself, that the Supreme Court of the United States has really been trying to reduce the power of federal agencies, and this decision should not be read in isolation as sort of a one point. What we're seeing is more searching judicial inquiry into agency actions. And so it is quite likely, whether it's because of Chevron or whether it's because of how the courts today are looking at agencies, that the agency will not receive the degree of deference it's gotten for the last 50 years when it comes to examination of noise issues. And I think there are more cases that are likely to be forthcoming. If we can go to the next slide, please. So what does this all mean for airport noise? Under the Loper-Bright principles, this is the principle under which Chevron deference was overruled, Congress has expressly delegated authority to the FAA in some limited circumstances. That is, they told FAA what to do. But the FAA then issued a series of regulations, not very many, but a couple of regulations. And most of what the FAA has done has been through policy. And it has not been through interpretation of law or interpretation of regulations, but through policy. That is very common for the agency. The agency issues relatively few regulations and a lot of policies, and those are still going to be respected. So, next slide, please. What happens as a result of either the death of the Chevron deference principle or as a result of increased community and airport pressure or the neighborhood environmental survey? what happens if FAA decides or Congress decides to alter the threshold of the metric, the 65 or the DNL? There will be a ripple effect through any number of statutes that affect airports, and the significance can't be underestimated. I mean, it's not just how noise is reported, it's how money is going to be spent, how money can be spent around airports, how communities plan for noise, and so on. So, next slide, please. So what I'd like to end here with is a proposal for how we might move forward in light of both the changes in the law and the changes in society. So, number one, I would suggest that the idea that there is, next slide, please, that the idea that noise is the same in all communities was probably not very smart in 1979 and is foolish today. I mean, these are pictures out my office window and my living room window. Those are different places. And the idea, I mean, I will tell you at home, when a plane flies over my home at 30,000 feet, it is really irritating because I can't hear any of the hummingbirds. And I'm not joking, I really do feel it. My wife thinks I'm nuts, and she said, that's because you do noise work all the time, you pay attention to it. But that same plane flying over Times Square in my office in New York, you think I'm going to hear that? Of course not. So the idea that we're using the same threshold and the same metric in Times Square and in rural Colorado doesn't make a lot of sense. And I think we have to accept the fact that airport sponsors and the FAA have to adapt to the needs of the community. Number two, and this is probably the most controversial or least appreciated part of what I'm recommending, and that is that local communities have to take the responsibility for real land use planning. An awful lot of communities say, it's the airport's problem, it's not my problem, and we're not going to zone out residential. We need more residential. Or we're not going to allow apartment buildings because we are a single-family home community. And communities have got to recognize that the airport is there, they are there, and that real compatible land use planning has to take place. And we are dealing with this all over the country right now, where the FAA has said to communities, I know you're not in the 65, but you know what? I know this community. Please don't put McMansions there. Because you're outside 65, I can't prevent you from doing it. It's not illegal. It's not illegal under state law. It's not impermissible under federal law, but it is profoundly stupid. And the FAA has had very little success in convincing communities, no, you shouldn't. I worked on one of these where there were homes that were outside the 65 and the chimneys were too high under the Part 77 surfaces for obstructions. And so what did? They lowered the chimneys. It's like, guys, do you know how low the planes have to be that you have to lower the chimneys? Okay, but the community thought we solved the problem. We lowered the chimneys, and the FAA was just flummoxed because the community refused to recognize the fact that putting homes in that location was foolish. Number three, and this is very difficult, and I'm sorry if all of this has been a lawyer's relief act. This is going to be a Gene Reindel relief act. We need to recognize that noise energy measured in decibels is not the only way to report noise impacts. And we have seen this particularly with respect to NextGen and to concerns about overflights. The actual noise levels of the aircraft that are generating a lot of concern in the community are really not that high given usual measures of noise. However, it's sort of like water torture. Drip, drip, drip. If your faucet drips once every 3 hours, you're not going to notice it. If it drips every 3 seconds, you are going to notice it. And so it's an occurrence problem. Somebody who previously had noise that was not very loud, but it occurred once an hour, and now it occurs every 3 minutes, it's an occurrence problem. So we are really using, I think, the wrong metric, given how much the noise level, the decibel level of aircraft had decreased from 1979 until 2024. We're using the wrong metric. It's not about quantity of noise. It's not noise energy anymore. It's occurrences. It's difference between ambient and the event. How long does the event last? And there are metrics to do this, but we have to find them. Number four, then this is where the FAA folks will get really angry at me. I'm trying to make sure, by the way, that everybody is angry at me by the time I finish. And I think I'm almost there. we have to accept a limited degree of inefficiency in the balancing. That is airport noise mitigation and airport noise abatement measures have started with the presumption we may not change the efficiency of the system, the national aviation system. And that is a great principle, but something has to give. We have to have more balancing, I believe, that says, I mean, let's take the South Bay, for example, okay? Maybe we are going to have to introduce just a little bit of inefficiency. Sorry, Kevin. Just a little bit of inefficiency. Just a small bit of inefficiency in order to achieve noise benefits, okay? Now, I'm not saying let's close down SFO or anything like that. What I'm saying is that balancing that we did in 1979 and 80 that came up with a metric, we have to do the same kind of balancing that says, okay, how about we do a little tweak here and a little tweak there? And remarkably, at least from what we've seen, is those tweaks can be pretty small and be pretty effective. Number 5, depending on who you talk to, people say airports have to adapt to their communities, or communities have to adapt to their airports, or the FAA should address air traffic based upon efficiency of the national aviation system. And I think all of those statements are wrong. I think that we really need to recognize a shared responsibility. And you were pointing out, Mr. Chair, that this is the oldest standing roundtable in the country. I think that's really a testament to the fact that as to this item, San Francisco is leagues ahead of, if not every other community in the country, at least most, in that you are beginning to look at the shared responsibility, and you have airport staff here, and you have community staff here, and you have planners and so on all around the table. And that is remarkably unusual. You may not appreciate that because you've been doing this for so many years, but around the country, there's very little shared responsibility for the noise problem. And number 6, federal legislation is possible. But, you know, there's a reason there's a joke, you know, well, God, that would take an act of Congress. The reason is that an act of Congress is really very, very difficult. And Congress has proven superb at doing nothing. And when it comes to noise, they are spectacular at telling the FAA to think about noise. Really, this time we mean really think about it. And anybody who's looked at the FAA Reauthorization Act of 2024 will recognize that the Congress said, no, last time we were kidding, this time we mean it. Will you please do a study? And so asking Congress for help, I think, is unlikely to be particularly productive. So I've probably gone on longer than anybody wanted to hear me talk tonight. There are some sources of materials on the last slide for anybody who has the slides, but if you still have any patience, I'm happy to take some questions. Thank you.
Mr. Kirsch, thank you very much. It's an incredibly informative and highly relevant discussion, and we appreciate you being here to share it with us. We're going to open up for discussions and comments and questions from the members. Then we are going to go to public comment and allow the public to make some comments, and then we'll come back to member comments at the same time, or right after that. So with that in mind, let's open up to any questions that the members may have. Member Krolik.
Oh, thank you. Thank you so much for the presentation. That was fascinating, and we did learn a lot. It seemed to me in the beginning, when you were talking about the decibel level not having changed since 1979, the 65, that you were leading us towards adopting a lower decimal level. But then at the very end, you said not through federal legislation. So what are you suggesting in terms of that?
Yeah, you think I know the answer? You know, I'm just here to give the critique. It's very hard, and here's the reason. I think that when you get much below 65 decibels, I'm not sure decibels are the right way to measure it, okay? We could say, how about 55? And the fact is that 55 would decimate land use planning in most American cities, okay? Because so much of the property around airports would be noise affected. I think we have to be way more nuanced and say, I mean, I'll make this up just as an illustration. If your population density is below X, and if you are a resort community, and if your average home price is X, here's the metric you should use. And if your homes around the airport are all 4-story condominiums, and there is urban traffic, and there's a railroad, then your metrics should be wide. In other words, we should be way more nuanced in saying that DNL as a metric is not useful when we are looking at very, very tailored problems that are very different in the South Bay than they are in, name your other favorite community. I just think that a single metric doesn't work, frankly.
So just to follow up, so are you suggesting trying to change that at the local level, airport by airport?
Yes.
State by state, airport by airport?
Look, the FAA, bless their hearts, are still under a congressional mandate to have a single metric and a single threshold, and they're going to continue to use that for the purpose of funding and airport funding and mitigation. But that doesn't mean that the community can't say, in our community, it's really important that we don't put any residential there because we know that there's a flight track there. Instead, we're going to put commercial. And let's get good data so that we have a good basis for making that decision. No, the FAA is not going to probably help us fund that if we're outside the 65. But even that can change over time. So I think it's a little bit of a bottom-up rather than a top-down approach to looking at how we should measure noise, how we should report noise. Sorry.
Thank you. Member Eakin.
That was a really good question, and I enjoyed that answer, so I don't really want to stop that. Mine isn't a question, it's just sort of a comment that maybe elicits conversation. But, I remember when LA was really, really smoggy, and everyone just accepted it, and it's so much better now. And it wasn't federal regulations or court cases. It was technology. The catalytic converter got invented, and then all of a sudden, smog got solved, more or less. And I live close to Woodside Road. If there were no catalytic converter, they would not have built housing where they built my house. And the same with the noise. I'm assuming it's not a catalytic converter, but some sort of technology that enabled the whisper to become obsolete. So I'm a technophobe. I don't like technology, but is the answer technology? Are we just going to get quieter and quieter planes, and should we just be investing in scientists?
Yes. Look, aircraft are getting quieter and quieter, and we've gotten to the point now where a great deal of the noise from aircraft is from the aircraft frame, not the engine. And so, yes, they will continue to, and Gene could probably speak to this much better than I can, but I would argue that if you take some of the quietest aircraft around, you take the electric aircraft that are really quite quiet, if that electric aircraft flies over your home 700 times today, you don't care what the decibel level is. You will notice it, and you will get irritated. And that's why I'm saying that looking at it as a purely noise level question may not be the right way to look at it. We may need to look at noise level question when we're close into the airport, when the average noise is 65 decibels, then looking at noise makes sense. But when you are, anybody here from Palo Alto? When you're in Palo Alto, and this is so far outside the 65 decibel noise contour for SFO that it's sort of a joke, right? But people in Palo Alto really do have a noise problem. Well, and Gene, I'll quote one of your founders who said, how do you know whether there's a noise problem? See how many community people show up at a meeting. Okay? That means there's a noise. Don't tell me what the decibels are. The seats are filled because people are concerned. And then the question is, okay, what are they concerned about? And that's where I'm talking about an answer to your question. Why is it that people in Palo Alto are concerned about noise, even though objectively they, quote, shouldn't be? And so I think your point about technology is a good one, but I also think that we need to be way more nuanced in looking at noise and saying, understanding the nature of people's irritation and why noise levels that are so low in Palo Alto still make people upset, whereas they may not in another community that seems to be similar.
Thank you. Member Schneider, then Member Hindi. Before we go to that, I'd like to recognize Member Antonio Lopez from East Palo Alto joined us. Let the record show he was here at the beginning of the presentation. Antonio, welcome. Thank you. Member Schneider.
Speaking of Palo Alto.
So first, thank you. Enjoyed the presentation. I'm going to ask you a lot of questions because I represent Millbrae. I grew up here in Millbrae. I also went to school in LA and swam and ran in LA in the 70s and 80s. So I lived through air pollution, and I'm an environmental scientist. Okay, your slide here that you call the historical record order of magnitude exposure reduction despite traffic growth, I'm trying to figure out the right way to say it. Your argument for now, we should be looking at occurrence metric, but I like that. I like the term occurrence, and is that the national term we should be using? The problem with your slide is it doesn't reflect occurrence.
That's right.
On that. So, but I do love this, and I've been trying to figure out how we could graphically represent occurrences, because you are sitting here in Millbrae, and what you are hearing are the planes taxiing and the planes departing. And we go back to Kaya's question about technology and airplanes. Airplanes, in any environmental problem, you go for the easy stuff first. So they've gone for the engine flight noise in the air, not the departure noise. So what we get is departure. What SFO San Bruno get is that rumble of departure on that. So I argue a little bit about things have gotten better when it's only gotten better in certain areas, and it certainly hasn't gotten better for those of us who are in that low frequency noise area on that. But if occurrence is that, do you think we have a place to go in? Because here at night in Millbrae, you can go several hours with no quiet. And because of our topography, which makes us different than other airports, and the technical nature of low-frequency noise, it can get louder as it gets concentrated. Do we have an argument then that we are different? And I'm sure every airport, but we've been told by our amazing staff that SFO is somewhat unique in that the runways push back into the hillsides, and that makes 3 of us or 4 of our cities extremely noisy.
Well, I would say, with no disrespect intended, yes, you are unique, but so is every other airport. And that's my
They'll have
point.
their unique situations, yeah.
My point is, maybe instead of having a single metric nationwide, we should have a single questionnaire nationwide that says, okay, we are going to need to find out information about this community. Do you have hills? Mm-hmm. Do you have a particular runway alignment? Do you have single-family homes? Do you have industrial? I mean, you know, I haven't come up with it, but I could probably come up with 20 questions from which we say, okay, given your answer to these 20 questions, here is how we are going to report noise in this community. You are a community type 62, and this community over here is a type 712. I don't know, but what I'm saying, though, is if we tailor that to the recognition that there are factors outside the airport's control that affect airport noise and the consequences of airport noise, I think we'll do a way better job. That, you know, the example I had of the community where they were going to chop off the top of the chimneys, you know, was a pretty rural. Well, it was a far suburban community. And the noise levels there were extraordinarily low. And one of the reasons the FAA said, please don't build here, is they knew that 65 didn't work. These were people who were moving to 3-acre plots. And if you're going to put a house on a 3-acre plot, my guess is you probably expect a degree of quiet that people in a condominium at, you know, on Market Street in San Francisco don't expect. And so we just have to, I think we just have to be more site-specific.
Thank you.
Your point, your community is different than a community at the other end of the runway.
Just as every city is different from any other city. Your last comments talked about shared responsibility. The problem we have on airport land use is many of our cities are older. This community is older than the airport on that. And yet, the airport has expanded over the decades. It's moved runways closer over the decades. It's moved ground operations in gates closer into that. And we have no say because the planning goes up to San Francisco. It's not even in the same county on that. So unless we can have shared responsibility and shared revenue, there is no hope for mitigation.
That's sort of my point, is that when it comes to land use compatibility, we still look at the boundary lines of jurisdictions and say, sorry, that's Millbrae, it's not my problem. Or, sorry, that's San Francisco, that's not my problem. And I think if we are really going to achieve long-term solutions, we're going to have to set up mechanisms, legal mechanisms as well as policy mechanisms that say, in the vicinity of SFO, we're going to all do this together. That's unusual, and there are some rare places, DFW Airport or Denver Airport, that have so much property around them that they can in fact do that because they have so much vacant property. But that's very hard. Or there's some places where there is in fact one jurisdiction around the entire airport, and that's great, but that's the exception.
Thank you.
Thank you. I would make a quick note, and then Sam will get to you in a minute, regarding your last comment on shared responsibility. I think this organization and this our series of communities have made incredible progress over the last few years. The FAA is with us. The airport's with us. We have community groups with us. The Palo Alto group has been very vocal and very active and very supportive of a lot of what we're trying to do. So I think there is a lot of progress. The question is that the runway we've come from is so small compared to the runway we have yet to go, and that's really the challenge. And it's further compounded, which all of us know, with respect to the communities taking charge of the land use policies, is our state mandates with respect to affordable housing, which makes it even more complicated. And so there's that mix there. So what I'm hearing from you is there might need to be some vocalization of a concern at the state level with respect to housing, with respect to the noise impacts of that and the health impacts.
Yeah, precisely. Look,
Yeah.
you know, I'm not just being flattering when I say I think you've done a better job here than most other places in the country, but I get upset when people say, but state law requires. Well, then let's go to the state legislature.
Yeah.
You think going to Congress is hard? You know, let's go, or let's create a regional planning body. You know, I mean, there are other solutions. And to say we have to work within the existing structures is like saying we have to work within the existing 65 DNL, because that's what it is. If we're really going to take a blank sheet of paper and say, what's the best way to address the problem of airport noise in the South Bay? Okay, let's figure out what has to change. And maybe it is federal law. Maybe we have to go to Congress. I'm skeptical, because I think there's an awful lot that may be done in Sacramento or may be done regionally by your council of governments and so on.
Great thing. Member Hindi.
Thank you, Chair Royce. Wonderful guest. Thank you for bringing this presentation and this guest, Mr. Kirsch. And thank you, Kathleen, for bringing Mr. Kirsch as well. Mr. Kirsch, thank you for this fascinating and very informative presentation. You covered history, you covered where we are today and where we are hopefully going in the future, or at least your recommendation where we're going to be going in the future. Clearly, it's very disappointing and sad that we are still using metrics and the threshold from the 1980s as everything around us evolved and everything around us changed as we change in time and technology changes. It's a challenge, obviously, with government, and especially when it comes to the federal government. Clearly, everything is very slow and every bureaucratic and red tape, and it's really hard. And from what you kind of joked a little bit about with your language about the FAA will appoint a committee to look into and all that kind of stuff. But that's, unfortunately, that's most likely is going to be the truth. I want to, on your to-do list or performance plan, I think I couldn't agree with you more on the efficiency part. Clearly, the FAA is mandated currently by our Congress. Safety, which no one dares to argue about, but the efficiency part, I think that's a soft point where there should be a balance between efficiency and noise impact in our community. And I don't look at noise impact as necessarily annoyances. It's more about health issues that affecting people's life. And so hopefully we get to that. But while we are waiting for the FAA to see how they're going to perform, I got a specific question for you. I don't know if you could help me. How can we get the FAA to work with airlines and the Roundtable to encourage airlines' use of less noisy flight procedures? For example, right here in the Bay Area, runway 28 obviously is the landing runways. How do we get the FAA to use more offset procedures and lessening the noise on the communities, especially when you have low traffic or especially at nighttime?
I think you put your finger on one of the most difficult parts of dealing with noise, which is we have a whole bunch of stakeholders, many of whom don't have any stake in the community. And I don't mean the FAA, by the way. I mean the airlines, I mean the aircraft manufacturers, I mean folks who, you know, don't look at this necessarily, or as one pilot said, all I know is the place I put my plane when I'm done. they don't know the community, and it's really very, very difficult. Now, there are some airports that have been really quite successful in working with their airlines, sometimes using jawbone power, sometimes a little bit more than that, because there are limits on how much an airport can do there. And some have been pretty successful. But it's a long-term, lots of effort to get the airlines to start paying attention. And I don't mean to say the airlines are irresponsible, because that's not the case. It's that look, they're running from 500 different cities around the world, and this is just one of them, and if they change here, they're going to have to change there, and that's the whole principle of a national system, is the airlines don't want to have to change for every single airport. And so it's a matter of I think, really fine-tuned tweaks around the edges to the airlines to say, look, instead of taking off at midnight, could you think about 11:50? Let me show you how we can do 11:50. Can we provide an incentive for you to take off at 11:50 instead of midnight? I'm not talking about taking off at 8 p.m. instead of midnight. That's not realistic. But I think if you make some tweaks around the edges and have the airlines join in these sorts of conversations, I think there is some hope. It's really hard. And I would say of all the people at the table, the airlines are the hardest.
Yeah. Well, thank you for that, but my question was more, clearly I appreciate that answer and how important to involve the airlines and to have them see it from different perspectives, really the impact on our communities. But my question is more like towards how do we work with the FAA? How do we get the FAA to move having their towers to direct the flights to go, say, for example, more over the bay in an offset approach rather than going over the communities?
I think we're beginning to see a shift in how the FAA is looking at this. And that's really very, very good news. I mean, as recently as 5 or 7 years ago, if you talked to the FAA about noise and it was outside 65, they shut the door on you. They just didn't pay attention. That's really changed in the last couple of years. The FAA has had more recognition, frankly, sometimes because they've been beat over the head with it. They've had more recognition of en route noise, the next gen and the Metroplex noise and so on, and they've become more aware of the fact that they cannot ignore this. And so, like any good bureaucracy, it takes them a while to change. But I'm seeing a attitude shift, and I'm hopeful that the community noise survey and the number of comments the agency receives to that are beginning to change. And I've seen a significant change at the senior-most levels of the FAA, that is the Associate Administrator for Airports and some of the other folks who said, look, we really have to deal with this. And that's been a pretty important and significant improvement in the last couple of years. Now, you're not going to see that on the ground in 24 months. It's going to take some time. But I think if there's one piece of advice there is don't give up on the FAA and don't let them get away with it. And by that I mean that you just need to keep that pressure on them. And one of the FAA's, I think I can say this publicly, but one of the FAA's least favorite people is your Congresswoman, because she just doesn't let up, which is just wonderful. Or, if you're on the other side, just a pain in the neck. But I mean, there are people like that who can be really very, very helpful. And when we have an agency that no longer has a bright line and say, I will stop talking to you if you're outside the 65, I think there's a lot of hope there.
Thank you.
Member O'Connell, and then Christine. Is your card up? Okay. Terry, floor is yours.
Thank you. The feedback's driving me crazy. So on one of your slides, you mentioned low noise energy but high frequency with the electric vehicle, electric takeoff. And in my understanding of sound, when there's a mosquito in the room, it's not very loud, but you're not going to sleep because that buzzing is there. Do you have any recommendations on how we can manage what may be coming down the road with the multiple low frequency, but the low energy, high frequency noise that's going to be coming from those kind of vehicles?
This may be the toughest issue of the 2030s or late 2020s and 2030s. And I don't have a good answer for you. Here's the problem. Number one, we don't really know the noise signature of these new aircraft very well. Number two, and maybe more importantly, we don't know where they're going to fly. They may be like helicopters that don't follow particular paths, or they may, in fact, follow paths. And the FAA is right now looking at that question. And I think here's where pressure on the FAA, pressure on the industry, pressure on Congress to say it's quite practical, for example, to require these aircraft to follow roads, much as helicopters do, particularly in more urbanized areas, or to avoid certain areas, this park or that park. But not only is the technology new, which means we don't really know how to use it, but how these aircraft are going to be used in practice, what's the use model, is not really very well known yet. Are the small electric aircraft going to be used for short hops between the shopping center and the home, or are they going to be used for longer hops from San Francisco down to Monterey? You know, we really don't know much yet, and so it's all very, very new. And I'm kind of scared about it because we just don't know what the impacts are going to be.
Thank you so much. From what I'm hearing from you, I hear a recommendation that it's something we should get on top of before it becomes a problem so that we can try to mitigate that.
Absolutely. One of the most important things, and there are several communities in the Bay Area that are doing this, is the vertiports. These aircraft will probably not fly out of airports. And a lot of the manufacturers are going around buying up property for vertiports in communities where they want to operate. And if you don't have any zoning or land use controls that prohibit the establishment of vertiports, they will do that. They will establish the vertiports and you will be out of luck. And so there are a couple of communities, again, particularly in the Bay Areas, that are beginning to look at how are we going to zone for vertiports so that the takeoff and landings are in places we like. It is remarkable how many Walmart parking lots have been leased by the electric aircraft manufacturers just because they might need them someday. I mean, this is all over the country. They're really very, very smart about this because they want to make sure that they get their vertiport in before the zoning gets adopted. So what we've been encouraging our municipal clients all over the country is get your vertiport zoning in place today.
So can, and this can be later and off the meeting, if you could give any insight to this group on cities that are starting that process so that maybe
I'm not
we
sure
can...
I can tell you because I think it's the ones I'm working with, it's still confidential.
Okay. Well,
Yeah,
thank you very much, and we'll have to just do some snooping on our own.
Yeah,
But thank you very
I'll
much.
think about whether there are any, there's several in the Bay Area. I don't know if that helps at all. But let me think if there are any that have publicly stated what they're doing that I can tell you.
Thank you so much. I appreciate it.
Okay, thank you. It's a great question, and that's a great piece of advice, by the way. Let's take a couple more questions, Sarah, then we're going to go to public comment and then come back to members. So Christine, you're next, and then Member Lopez.
Thank you so much for your presentation. You mentioned with the Supreme Court decision, there may be some opportunities for you legally, and I'm just wondering if you're seeing things already starting to come through, if you're thinking about things. One thing I'd sure like to know is if the whole concept of curfews and not allowing curfews, post, I don't know what the date was, 77 or so, whether cities might be able to challenge that.
No. That would be the ANCA, the Airport Noise and Capacity Act of 1990, prohibited airports from restricting operations, I'm going to oversimplify, without FAA approval. Now, could you challenge the bases that the FAA has set for approvals? Perhaps. But you need to first apply, and you need to first have the FAA turn you down. And that is such an onerous process. And frankly, most airports don't want to do that, don't want to put in restrictions. So I think that's very, very unlikely to be effective. That's a pretty important principle, that imposing curfews and restrictions are so far to the extreme in terms of measures. Remember, I talked about the balancing and maybe accepting a little bit of inefficiency. That's way to the extreme. So I don't see that as being productive, frankly.
Okay. And then this may not be a fair question to you, but when you mentioned, a national system here, I'm wondering if you know of anything internationally, other countries that have noise policies that we might want to look towards.
They vary considerably. And the U.S. has not just more air traffic, but the aviation system, the national aviation system, is much more important to the U.S. than most other countries, which are much smaller, and a much smaller portion of their commerce travels by air, for reasons that may be pretty obvious. And so for example, there are very, very stringent restrictions on operations at London Heathrow. There are environmental restrictions there. There are environmental restrictions at Schiphol in Amsterdam. So Sydney, when they built a new airport, had to agree to a whole bunch of restrictions. But those are unique to those countries' statutory schemes. And I think I would urge some caution in looking internationally, because our system is so different than a lot of those countries in terms of our national regulation, in terms of the importance of the national system. I don't think those are particularly good models.
Thank you. Member Lopez?
Yeah. I have to figure this out. I just wanted to say thank you for the presentation. I thought it was very enlightening. Who's they? Oh, yes, of course. That was my joke. No, I just wanted to say thank you. And, it makes all the sense in the world what you're saying, and it's kind of baffling. It reminds me of our current Congressman Mullen. One of the things he's doing is trying to work on redefining or updating the Federal Poverty Act. That's been benchmarked from the 60s, that was done by a Brooklyn sociologist, right, like 60 years ago. And now, of course, we have internet, transportation, like so much has changed. But we have a metric that's over half a century old. And I guess when I'm hearing you speak, my comment is it reminds me of just the political will of this state to pass a housing element. We have ABAG, we have a metric whereby we have different cities where we calculate how much housing works, and it's a multivariable system. And it just kind of baffles me that we haven't arrived to that in the level of noise. And you're absolutely right. In East Palo Alto, where I sit as mayor, we have the Palo Alto Airport adjacent to us. And just the perception of folks saying, working class, blue collar folks, hearing the planes at odd hours of the night, so much of that isn't even quantitative. It's just the history and the experience, the culture, of course, the topography of that marshlands. And so I guess I just wanted to thank you for kind of putting language around what I have perceived so much in my city has been the issue. And I do find it a bit cynical that for you, Congress is like the last resort, because you would think that would be the first stop to fix this, right? It seems as if so much of this is just political will, or lack of a political will, to create a series of metrics as we've done with housing, or at least we're pushing toward that helps to address the problem.
Yeah,
So
and I mean, look, you can go to Congress. I'm just telling you that it's not easy. But let's not minimize the achievements that we've made in noise reduction over the course of the last many decades. I mean, I don't want you to think that we have the same noise problem we had in 1979. The noise problem is by orders of magnitude less. And my argument is that's terrific. We've reduced engine noise. We've reduced the number of homes that are exposed to excessive noise. The problem is, what I'm saying is, we've sort of reached the limit there, using this metric and engine technology, and that now we need to start looking at different metrics, because people's expectations now continue to rise. And the excuse that, well, people accepted 65 before, then you should accept 65 now is not a good argument, I don't believe.
Thank you. With that, we're going to go to public comment, and we'll come back after public comment to final member comments. So with that, Diane, if you could please open public comment and see if there'd be any comments or questions from the public.
Yes, we have one speaker in the room that would like to speak, and then one on Zoom. So,
Okay, on the room? Sir, if you'd like
Sir,
to.
yep.
Hello again, Ramy Tan, Pacifica. Thank you, Peter. That was a very, very thorough report. Kind of disappointing on the answers that was given to Ms. Christine Bowles regarding the curfew, because it is it's a bit unfair because several airports in the Bay Area, I think Oakland, Oakland and San Jose have curfews, and there are a number of airports in the Southern California that have curfews, and the fact that we can't get one, that seems to be a little bit unfair, and to the airports, who which the communities kind of grew around them. Just kind of a thought. I mean, a lot of countries that grew around the airports, like in Hong Kong, they actually moved the airport on the edge of the city, because it was right in the middle, and the actual real estate was so valuable that the airport sat on, that they were able to do that. So maybe that's just kind of food for thought regarding this whole issue we're having. The airport is, on very premium land. And does it make sense to move the airport somewhere else where it's not as premium? Or, do we want to relax some regulations and put the airport out in the middle of the ocean or in the middle of the bay where it doesn't disturb buildings? So it's kind of a thought. Thank you.
Thank you, sir. Okay, we have a comment on Zoom.
Yes, we have Miss Darlene Yapley. Miss Yapley.
Okay, Darlene, welcome. If you can unmute your mic, the floor is yours.
Thank you, Mr. Kirsch. Question number one. The FAA interprets ASNA to be a single metric and a single threshold, but ASNA asks for a system, which means there could be multiple metrics and multiple thresholds. In the NES study on page 1, it is actually inaccurately quoting ASNA as being a single metric and a single threshold. The second part about ASNA is there's methodology. So it's not just the threshold and the metric, but the fact that ambient noise isn't used, which is, as you pointed out, the difference between New York and Denver. The number or the occurrence or the count of events is not being considered as impact. And lastly, using a 365-day, 24-hour average completely distorts the information compared to peak hour. So my question to you is, using Loper Bright, are all of those challengeable in terms of how the FAA, whether it's abatement, mitigation, planning, or reporting? My second item is that the FAA reauthorization asked for an aircraft noise advisory committee, which will adhere to FACA. And can we use Loper Bright if that committee is not set up that will adequately represent the community? As Chair Royce had an approval of a letter talking about that type of community inclusion. The concern is the quantity of community people that are included and the composition. If they only let people that are right in the 65 DNL contour as members and not people that are affected, for example, by NextGen, it's hard to see how that committee, who is then going to make recommendations on the noise policy, to be adequate. So that would be the second Loper Bright question. Those are my questions.
Thank you, Darlene. We'll hold the responses till we get all the public comments. Diane, do we have other public comments?
There's no other public comments on Zoom, and we received another request from an audience. Would you allow Mr. Remy Tan to speak again?
I'm sorry, the same person?
Yes.
That was your comment.
Oh, okay. I thought you. Okay.
Thank you. Thank you.
There are no other comments at this.
Okay, with that, we'll close public comment and bring it back to the committee for final discussions. and also responses, if appropriate, to any of the public comments we've heard. Mr. Kirsch, would you like to respond to the one question? Not obligated to, but if you would like to, we'd appreciate it.
One thing I've learned to do is not to give legal advice in community roundtables. And so, Darlene, I understand your point, and all I can say is I think that challenges to the FAA's use of 65 and DNL are likely to come, and I don't want to give any projections as the likelihood of success, but I don't think it's going to be quite as easy as you may think. On the subject of the ANAC, the Airport Noise Advisory Committee, I expect the FAA will be announcing within the next week or two how they're going to appoint those members. And I think your point is very well taken, that it would be good if the FAA does not limit the members to people in areas subject to 65. I hate to predict what the FAA is going to do, but I think the FAA has heard the message about outside 65, and I'd be kind of surprised if they set 65 as the sort of limit to the areas where they're going to consider representation. I hope that's not the case, and I really don't think. I think they understand that.
Great,
but we'll
thank
see
you.
when they appoint that relatively soon, I think.
Thank you. And that was a topic of the letter that we approved earlier this evening, addressed that in part. Are there other member comments before we close the presentation? Member Schneider.
I'm not sure if in the existing work plan for the Ground-Based Noise Committee, there is room to discuss occurrence metrics. At some point, it would be great in a less crowded room to sit down and talk about metrics. Or could it be moved over to the working committee? Just a suggestion. I really do appreciate having an actual name for just the sheer amount of time in an hour people are experiencing that. So that's a great takeaway. Thank you.
Appreciate it. I think that may be a topic for the Strategic Planning Committee to discuss whether or not we need some special discussion around metrics, because I'm not sure it's exclusive to the ground-based noise, but it's clearly relevant to it. Yeah. Are there other comments? If not, Mr. Kirsch, I want to thank you again on behalf of the roundtable for your agreeing to attend and to be here, and for an excellent presentation. I think the topics that you discussed tonight are ones that we've been getting questions on, trying to understand, trying to figure out what our role might be as we move forward. It's clearly not going to be a quick road, but I take to heart your comment about this being a shared responsibility, because I really do think the only way this gets resolved is by getting everybody to the table. And I am optimistic, because I have seen the last few years, under the leadership of Mr. Hindy when he was chairman and his predecessors, the fact that we've gotten more involvement by the different stakeholders. Probably still not all of them based on a comment you made, but we clearly made some progress. But this will be slow progress, but it's again, and I want to make one more comment, because Sam made the comment. It's a word of art, the word of noise, but to our citizens, it's not a noise. It is a real hardship, not just from a noise component, but from a health component. And so it is something we take seriously, and we do appreciate very much your sharing your knowledge and your expertise with us. We do have a small token of appreciation, though. So if I could have you come over, I'll present this to you.
White noise, white noise.
It's actually you take that show. It's a placeholder, it's a star. It says with appreciation, Peter Bush. Thank you.